a Chapter 7, it is $299, and to file a Chapter 13, it's $274. There is a vehicle in which you can actually ask to waive the payments or request installment payments, and typically the courts will allow that if your income is $16,245 or less a year. Once you file the bankruptcy petition and the schedules, an automatic stay is put on your bankruptcy. What that means is all of your assets and all of your debts are frozen in place at the time that you filed the bankruptcy, down to the minute. That's why you'll hear oftentimes individuals filing the bankruptcy to stop a foreclosure. Once you file that bankruptcy petition, it will stop the foreclosure, at least temporarily, like I referenced earlier. Again, it will stop all collections and, of course, the foreclosure proceedings. For a creditor to resume collections against you or reinitiate the foreclosure proceedings, they have to ask special permission from the court. We call that a lift of stay, and it is done through a motion of lift of stay that would happen later on in your bankruptcy.
I have a question. Will secured creditors appear on these credit reports?
Yes, and again, that's a very good question. The credit report will list all of your creditors, and you want to make sure that you're very detailed about listing each one of those creditors to include the secured creditor. In addition to that, I want to stress that oftentimes debts are sold to various companies, such as either they're sent out to a collection agency or the debt's been sold, and you may see the same debt for the same amount listed 3, 4, sometimes 5 times on your credit report. We recommend that you go ahead and list each one of those creditors on your bankruptcy schedules. It doesn't hurt to just be as complete and accurate as possible. Okay, number 2 is you want to categorize your debts. This could be a little bit difficult at times, but we're going to try and give you some information on how to do that. It's important to classify your debt because it can determine whether the debt is dischargeable, and also whether you'll want to make some kind of repayment arrangements if you want to keep the asset, such as with a car, a secured asset. Now, there are 3 different classifications that we're going to talk about. The first one is secured debt. This typically happens when you have a debt that is identifiable to an asset, such as your car or your house. There's also a thing called a purchase money security interest that we want to explain to you. And what that means is that although it may not be a car or a home, it might be, say, a Sears appliance or something like that. When you purchased the item, the creditor actually told you, whether it might be fine print on the receipt or otherwise, that that item is considered a secured item and that they could repossess it if, in fact, you don't pay on the debt. So just be mindful of that. Yes?
If I file bankruptcy, how will that affect items where I'm a co-signer?
Well, with respect to a co-signer, the bankruptcy will not affect the co-signer's credit. They will still be liable for that debt, but you no longer will be liable for the debt. Okay? One other thing about the purchase money security interest is we try to stress that look at the fine print on receipts, locations or creditors such as Sears, Home Depot, Lowe's. You'll see fine print sometimes on the receipt identifying that it's a purchase money security interest, and that's how you'll know that item might be, they could seize the item for non-payment. The second classification is an unsecured debt. Now, these are a little bit easier. We're all familiar with credit cards. This typically, the debt is not attached to an identifiable item. The examples I like to give are dinner or medical debt or gas. The creditor can't come back and take your dinner that you've already eaten. So that's the best way to identify unsecured debts. Also, I'll note that payday loans are unsecured debt as well. Now, one example of an unsecured debt, which is a common knowledge, is that student loans are not dischargeable in bankruptcy, and I mentioned that earlier, but they are still considered an unsecured debt. Now, we have unsecured priority. That is a protected debt by law, and the debtor will have to repay the debt regardless of the bankruptcy filing, and examples of that are taxes and child support. Okay, the third important step in preparing for your bankruptcy is identifying your property. And now I'm on page 12 of your bankruptcy manual, and we've provided some charts here to help you focus on how to identify your property. What do I own? What is it worth? Is it exempt? Can I keep it? So you might want to take a look at page 12, and that gives you a list of things that you want to consider as far as preparing and identifying your property that you'll be claiming the bankruptcy debts on. Now, please be mindful that if you're married but you're filing individually, we just want to notate that with the community property laws, all of your assets need to be listed on your bankruptcy, even though you're filing individually. If you have separate property, separate assets, then those do not need to be listed on the bankruptcy for the non-filing spouse, of course. But be mindful if there's an inheritance or something along those lines and you've commingled some of those assets, those funds, with the community property assets, then that, of course, becomes community property and you would go ahead and list that on your bankruptcy schedules. Separate property most easily is defined as property that was owned prior to the marriage. And again, there's exceptions to that, but if you commingle the separate property, then same concept as the inheritance. You'll want to list that on your bankruptcy schedules, even though you're filing individually. Now, when we say everything needs to be listed on your bankruptcy schedules, we mean everything. If you've received any of the following items within the prior 6 months to filing bankruptcy, you do need to include those as well. Inheritance, any property that you received pursuant to a divorce decree, life insurance, winning the lottery, gambling winnings, anything like that. You're going to want to include it on the bankruptcy schedules, and just be mindful of that. Now, when you prepare your list of property that you own, you may find that you provide a very lengthy list to your attorney. However, you may not see that kind of detail in your schedules. Do not be alarmed. The reason why we recommend that you go ahead and be detailed on your list to your attorney is so that if they see anything that they need to identify to later on exempt, they're at least aware of it, and then there's not any problems with the trustee when he's reviewing your schedules and looking for assets that he might take to liquidate. Okay, let's talk about preferences and fraudulent transfers. You'll note that this is one of the key concepts I had mentioned when we first started. Just be mindful of these and make sure that you have a good understanding of what this is that I'm discussing. The trustee will review the following transactions quite closely, and so it's important that you understand it. The first one is a preference payment. When you're paying any of your creditors right before you file bankruptcy, the trustee is going to look at that transaction closely, because if he determines that the payment to the creditor could disadvantage the bankruptcy estate in any way, he does have the power to reverse that transaction. So just be mindful of that, and you don't want to make any payments to one particular creditor over $600, because that will definitely bring attention to the trustee as far as scrutinizing the transaction. The second concept is the concept of transfer of assets. Now, oftentimes it may be very innocent. Let's say, for instance, you recognize that you're having financial problems and you're struggling and you have a boat, and the boat has a lot of equity in it, so you decide to sell the boat so that you can create some money to pay off your creditors. But ultimately it wasn't enough money to pay off all of your creditors, and you do decide to file bankruptcy. Well, the trustee is going to look at that transaction, that the sale of that asset, and if it's significant enough where it disadvantaged the bankruptcy estate, again, the trustee does have the power to reverse that transaction, and they call that just transfer of assets. And any money that you use to pay off creditors from the sale of that asset, that would be the preference. You prefer to pay this creditor over another creditor. And ultimately, remember, what happens is it's the trustee that will ultimately make the decisions on which creditors get paid and how much they'll get paid based on his analysis of your financial circumstances. So this is true, by the way, even if these are good faith purchasers or it was in good faith that you paid a creditor. Typically, the trustee can look back 6 months if it's a good faith purchaser, meaning it's just that you advertised the item that you were selling and someone called you up and said, I want to buy this asset. You don't know them, there's no relation. The trustee will look back for a period of 6 months prior to filing bankruptcy. Again, they have even a further look back of 1 year period if the individual that purchased the asset was an insider, or the payment that you made was, say, a family member within 1 year. The trustee is going to be able to look back that far and possibly reverse the transaction. So just be mindful of that as you're preparing to file bankruptcy. Okay, next we're going to talk about the trustee's role. Well, who is the trustee? The trustee is a court-appointed individual who is actually going to be reviewing all of your